The Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning. Please be seated. We're here at the time set for oral argument in file number 2026-0039, Travis McDermott versus the state. Sitting this morning are Justices Jared Tufte, John Jensen, Douglas Barr, and Mark Fries, and I am Lisa Fair-McEvers. Arguing this morning for the appellant, we have Kara Krauspar, and for the appellee of the state, we have Ms. Tiffany Sorgan. Ms. Krauspar, I see you have 5 minutes reserved for rebuttal. Is that correct? Yes, ma'am. You may proceed.
Good morning, Chief Justice, Justices. May it please the court, I'm here representing Mr. McDermott. This is an appeal from a denial of post-conviction relief. The first and only issue is that the district court erred in that denial. The order denying is at record 48. Initially, in sort of the summary of what the court ordered, was that Mr. McDermott's petition was his entire petition essentially was a misuse of process because he did not raise these issues on direct appeal. And I think that that would be clear error factually. I also think that that would be a legal error because and I also believe it's just a misunderstanding of what Mr. McDermott was arguing, with, I will concede, the exception of the illegal sentence, because that really doesn't necessarily fall under ineffective assistance of counsel, but everything else in his petition is under ineffective assistance of counsel. There is allegations that his trial counsel did not meet with him or minimally met with him a few minutes. I believe it was 6 times was what he testified to, 5 minutes for 6 times prior to trial. He never met his trial counsel, the attorney that actually was defending during the trial, until just before the trial occurred. He was dealing with a different attorney throughout the process leading up to that. They did not discuss with him strategy as far as taking the stand, not taking the stand, possible defenses, and he listed a number of things that he wanted raised in the trial, specifically stand your ground, specifically that he wanted to make it clear that he was legally carrying his firearm as far as it was legally purchased, and he was had a legal right to carry concealed, where the issue was whether it was illegal to be in the bar with the gun. He was ultimately convicted of manslaughter, but there was a negligent homicide lesser included. So these defenses or these issues that Mr. McDermott is raising in his post-conviction has to go with his mens rea. It has to go to what he was thinking and his thought process during this altercation at the bar. It's not just about self-defense. It has to do, although it is about self-defense, but it's about presenting his thought process to the jury. Additionally, there was I think it was paragraph 16 of the court's order, where again he found that there was a misuse of process about that there was improper jury taint due to social media posts, a lot of activity before the trial. And again, that goes to the ineffective assistance of counsel. I don't know how on direct appeal you would ever, without there having been a motion in the underlying trial about change of venue or something of that nature, I don't know how you would prove that on direct appeal. It's just not possible. You need to get at that through post-conviction, and part of what you're alleging in post-conviction is that your attorney didn't do the necessary steps to flesh that out to the district court. All of the testimony at the post-conviction hearing is from Mr. McDermott. So he's telling the district court, this is what the conversations I had with my attorney were. They were non-responsive. They did not essentially meet with me for any extended period of time. They did not go through statements. They didn't talk about if I took the stand, that parts of the video where he was making statements would be played to the jury. Again, none of that can be really misuse of process, which I think is the first error that the court makes.
Ms. Krauspar, as I understand it, he raised 5 issues.
Right.
You're really only arguing the ineffective assistance, right?
Well, I think all the issues, I would
I
concede.
understand how they can tie together under the ineffective, but
Right.
for the other issues like sentencing and things like that, which I know you conceded that one,
Yeah,
those are also distinct claims.
yeah, not, so yes and no. So he identifies them specifically, and the court identifies them that way. But if you look at his petition, he says that he was convicted, it's the standard language from the form, in violation of the laws of the Constitution of the United States and North Dakota. And that is generally what is the form version of ineffective assistance, because you're alleging a Sixth Amendment violation. And then all of his claims go underneath that. So I understand what you're saying, that he's identified sort of sub-claims underneath that initial claim, but he's alleging that his conviction was in violation of the U.S. Constitution and the North Dakota Constitution. And everything that he's talking about, I'm specifically thinking about this in a how would he bring this up on direct appeal? There's no way, except I can see the sentencing issue. If he believed that that was illegal for him to sentence him, that it was inappropriate to sentence him as not at a lower sentence, you would be alleging some sort of impermissible factor, you would be alleging some sort of illegal sentence.
I guess my question is the only claim we're really looking at then an ineffective assistance claim on appeal? Or are there 4 other issues?
Those issues are both ineffective.
Well, that's what I'm saying. Are they subsumed by the ineffective assistance? Are they
Yeah, I think
separate and
they-
distinct issues?
No, I think they have to be subsumed by the ineffective, because there's no.
So I think the question is, there's no argument about their standalone claims then?
Right, and that, I think that was what I was responding
I just want to clarify, we're asking whether you're
Yeah.
waiving the standalone claims, and all we're looking at is ineffective
I'm saying that they're
assistance.
not, I'm not waiving his claims, because that makes me a little bit, how you're phrasing that is maybe why my language is not as precise as it needs to be. But he's alleging that there was his conviction was obtained in violation of the U.S. Constitution and the North Dakota Constitution. And underneath that, he's saying that his attorneys essentially failed at every step of their representation. And then he is saying how they failed, essentially. So there are subsets in that claim. But so I'm not waiving anything other than I really don't think that you can allege an illegal sentence if you didn't allege it under. I mean, I do think there might be a
Right.
misabuse of process there. Did that.
So assuming we would agree with you that the court should not have made a finding of misuse of process on ineffective assistance of counsel,
Well, on any of these claims that he could not have raised prior to, again, I go back because it's the easiest and the most glaring example. I don't know how he would have raised on a direct appeal that the jury pool was tainted without a motion in the trial court saying, we need a change of venue because I can't sit a jury.
which would have required his attorney to do that.
Yes.
Right, and so it has to go under ineffective assistance of counsel. But the
Yeah.
court made the alternative finding that he failed to show his burden. So even if the court was wrong in applying misuse of process, which the state did raise it as an affirmative defense, you agree?
Yeah, they raised it in their, they just listed everything. They include latches, which I'm not even sure is a relevant defense anymore.
Well,
given
it's a defense that even if it doesn't apply, the court made alternative findings. So what
So-
difference does it make if it wasn't misuse of process, unless we agree with you?
Right, he does go on to, or the court does go on to discuss ineffective assistance, but again, it's really, so in paragraph, so in paragraph 3 is kind of the bulk of his order, or not the order, is the summary of his order, which is misuse of process and essentially not, prong 2 is not met, is on paragraph 3. On paragraph 16 the court talks about the social media tape and that it was not raised on appeal. Paragraph 24 talks about prong 1 and that the petitioner failed to establish, but that prong one under paragraph 24 has to do with communications with his attorney. So he doesn't really talk about the social media at that point. He talks about the self-defense. He talks about the discovery view. He talks, or the order goes through the video saying that, you know, there must have been some review of the video because he knew it existed. And this goes to my sort of next argument, which is that the court was clearly making findings that were clearly erroneous, or at least not based on any record. So several times throughout the order, and specifically in paragraph 25, the court is making a lot of assumptions about trial counsel's trial strategy, I guess would be the best way. So the court is assuming that the tactics were just that they were tactics, that they were intentional, that this was, you know, the self-defense that they presented was a strategic versus not, for example, bringing up stand your ground law, which Mr. McDermott wanted his attorneys to address to the jury. And the district...
in order to, I'm sorry to interrupt, these arguments about failure to present defenses, at post-conviction relief, then doesn't your client have to prove the stand your ground law applies to this situation?
So
if you're raising a defense that doesn't apply to your case, how can that be ineffective?
Sorry to interrupt, but you have to consider in the context of what he was charged. You know, he was charged with manslaughter, which is essentially knowing the risk and ignoring it. But there was a lesser included of negligent homicide, which is that you're just not even aware of the risk. So if his belief was I can legally carry this firearm into this bar and I can stand my ground and I don't have to retreat, if that is presented to the jury, that goes to his mens rea. This is what I was talking about at the beginning of the argument, is that this case turned very much on what Mr. McDermott was thinking at the time of the incident. So by not explaining to the jury, even if it was an incorrect assumption, the reasonableness or unreasonableness of that goes to the level of offense, and it even potentially goes to his self-defense argument, which is another thing that I think that the court misconstrues in the order, and I think that I still think Mr. McDermott doesn't understand that this is not, self-defense is not an affirmative defense, because he repeatedly in the post-conviction hearing talked about, well, he had to get on the stand and say something because there was nobody else, there were no other defense witnesses, and he was the only one that could explain that this was self-defense. That clearly was not explained to him, that this was not an affirmative defense, that he did not have to carry that burden, that the state had to carry that burden, and he still doesn't really appear to understand it at the post-conviction hearing. So in response, as a more direct response to your question, no, I don't think it's irrelevant if the law is incorrect or not, because we've had several cases where not knowing the law can go into the reasonableness of your conduct. We had the police case where the officer believed that, you know, he needed a signal to turn out of an alley, and this court said, no, it's still reasonable. Even though he was mistaken about the law, it's still reasonable conduct. The same can be said for when you're talking about manslaughter, negligent homicide, self-defense. Is that belief reasonable, not reasonable? But you still need to present to the jury what the belief was for them to make that determination. And that's what essentially he's arguing, or that's what he's telling the district court. I wanted this presented to the jury, and they refused to present it. And where my argument about where the district court went off course is that then the district court filled the gaps because the state didn't call the trial attorney to essentially contradict any of this evidence that came in, or to explain that, yes, we heard him ask for this, but we didn't do it, and here's the reason why. So essentially present a trial strategy, or possibly I was thrown at this case last minute and it didn't even really occur to me to bring that up. So that would not be trial strategy. We don't know because there was no testimony. But certainly what Mr. McDermott is saying is, I wanted this presented. This is why I wanted it presented. My attorneys were unprepared to go to trial. We barely discussed anything. And I met my attorney on the first day, I believe it was the day of or the day before trial started. So, and again, I'm pointing the court to paragraph 25 of the district court's order, record 48, where the district court says that even assuming that there was not, that prong one is met, so that there was a failure of reasonable actions on the part of the defense counsel, there's prong two is not met because essentially this could have been all trial strategy. Everything that's complained of could have been trial strategy. But again, that's assuming that there's no testimony that it was trial strategy. And that cannot be the standard. We cannot assume that a trial attorney actions are strategic without some evidence that that's the case. Otherwise, there would be no point, there would never be ineffective assistance of counsel because everything would just be assumed to be a strategic decision. We would never get at that prong two, no matter how unreasonable the conduct was. So I think that that's where the errors are. Specifically, that I think that the misuse of process was incorrect. I think that for the reasons I've stated, I think that the trial court tried to I don't know a better way to explain, but essentially fill in the gaps for the state by assuming that trial counsel was effective. Normally, you would have a trial attorney come to the post-conviction hearing. I've even seen some, depending on the judge and the case and the jurisdiction, but I've even seen some trial counsel just file an affidavit explaining what they did and why they did it. We don't have any of that here. And so in my brief, I specifically point out, this is all uncontroverted from Mr. McDermott. And there's nothing in the record that would indicate that he's incorrect or contradicts himself. So
I have a question for you, Ms. Crosspar. Did you cite the stand your ground law in your brief?
did I? No.
Is it cited in the record below? I couldn't find it cited in the record
So
below.
I think he actually puts in his post-conviction petition. He has a number, so his petition is 12 pages long, so record at 1. And I believe he puts it in,
I just did a find, trying to find where it was referenced
Yeah, so
below in
it's-
the record that we have, and it didn't come up with anything, and that's why I'm wondering, how can you, if it's not in the record,
Yeah.
how can you prove your burden
so
you should have had this if you don't even mention what statute it is and how it applies?
So he brings it up on page 10 of his petition. Specifically, he talks about self-defense, stand your ground. He refers to just as general self-defense, and then limits on use of deadly force. He goes through all of it, and then duress, excuse, constitutional carry. That's 10 through 11 on his petition. And then I believe in the closing brief at the district court level, they also talk about his defenses. Although I'm not specifically remembering if they cited to that statute. But he certainly discusses it at length in his petition. I think 10 and 11. Yeah. So I lost my train of thought, but I think I was essentially saying that I think that the district court erred in both its denial under misuse of process and that there was not sufficient evidence for the finding, or his finding that prong 1 was met is clearly erroneous, and his finding that there's evidence of strategic action by trial counsel, also there's no evidence of that, and so that was a clearly erroneous finding leading to an inappropriate legal conclusion, and so the case should be reversed. Thank you.
Thank you, Ms. Crosspar. Ms. Sorgan, when you're ready.
Good morning, Madam Chief Justice, fellow justices, members, counsel, and court. Tiffany Sorgan for the Ward County State's Attorney's Office. I was both the trial prosecutor on this case in the criminal matter. I also handled the post-conviction relief evidentiary hearing. I do know that Judge Cressup's order mistakenly refers to Christopher Nelson from our office handling that, but it was actually me, as you could see from the transcript. I do take a little bit of issue with one of the statements that Ms. Crosspar made a little later in her argument that the district court, quote, filled in the gaps for the state. On the post-conviction relief, it is not the state's burden. It is the petitioner's burden. And Judge Cressup's order made it very clear that Mr. McDermott did not meet his burden. In addition to the findings of the misuse of process, as the court noted, he also made the alternative findings that he did not meet his burden as it pertains to the ineffective assistance of counsel arguments, pointing specifically at those 6 separate subdivisions there, specifically as to the alleged failure to provide and review discovery. That was fleshed out in Judge Cressup's order. None of these issues with regards to the failures of Mr. McDermott could be said to be made on a clearly erroneous basis. Judge Cressup went into detailed reasoning as to why he made these findings. These were also set forth in the record on the evidentiary hearing. The court took judicial notice of the trial below with its transcripts, its pleadings, as well as the Supreme Court's decision in affirming that conviction and what was determined to have been already played or already discussed and what should have been raised on direct appeal. I don't think that there's really seems to be much of a contention with regards to the misuse of process aspect, except insofar as it potentially pertains to ineffective assistance of counsel. Mostly this focus seems to be on the ineffective assistance of counsel issue, and that the court assumed that there is trial strategy by trial counsel on this. That is the standard. Ineffective assistance of counsel, trial strategy is broadly assumed, as the case law makes it very, very clear that.
Do you have a case that says that? I don't recall that we've ever said, we will just assume it's trial strategy.
I'm not saying that it's stated that it's assumed per se, Your Honor. It is simply that it is a high burden to overcome, and that we are not looking at this through the distilling lens of hindsight as to the issues of strategy. And it is the petitioner's burden to overcome that this was not trial strategy, but ineffective assistance.
How does the petitioner prove it wasn't trial strategy when the attorney doesn't testify? The petitioner can say, we didn't discuss this.
That's the petitioner's, again, trial strategy at the evidentiary hearing to not call that trial attorney. The state doesn't have that burden to refute that. And while the testimony of Mr. McDermott was the only testimony that occurred at the evidentiary hearing, it is far from uncontroverted or uncontested. He contradicted himself a number of times during his own direct testimony as well as during his cross-examination at that matter.
So is what you're saying is that even though he was the only witness, the district court gets to weigh his credibility and could not believe anything he said?
I believe so, Your Honor.
Did the court make a credibility finding in its order?
There was not a credibility finding in the order, Your Honor, no. However, the court did make it very clear that Judge Cressup did not believe that Mr. McDermott had reached the necessary prongs to prove ineffective assistance of counsel, which was his burden to do. We do have specifically the issues with regards to the issue of whether or not to raise a novel or groundbreaking claim. I think, Your Honor, you raised a very excellent point with regards to the issue of how can you apply a defense without establishing that it even applies to you, and if there's no reference to it.
Well, there is a handwritten reference. Ms. Kraus-Parr was correct. In his petition, it was written, and my reader didn't pick up on that citation because it was handwritten, so he does cite to the statute.
It is and it is brief and it is fleeting. But there was, again, nothing that fleshed out that it was even applicable to him or what should have been utilized as or further fleshed out in there. It was simply a fleeting reference in a petition and not fleshed out at the hearing or in subsequent or in the closing brief. And that is the failure to, it's not ineffective assistance of counsel for trial counsel not to have tried to raise a novel or groundbreaking legal claim. That's not ineffective assistance of counsel, and that is the Yoni decision from 2021, Your Honor. I think that we have, really, just the issue primarily is that Mr. McDermott failed to make his burden, failed to meet his burden. He had the opportunity to do so. It was their decision to choose whether or not to call any additional witnesses, including trial counsel, any members of the Sand Law Firm who had represented Mr. McDermott at trial, whether that would have been Mr. Becker, Ms. Hewitt, or either Rick or, oh wow, I'm totally blanking on his name, Bill Sand, with regards to this matter, as to their strategy, their trial strategies or whatnot. The argument that he was not prepared and that was somehow counsel's fault, not prepared for my cross-examination at the criminal trial, is really difficult to wrap my head around, particularly his assertion that he doesn't believe that the video would have been not utilized had he not taken the stand. As it was made very, very clear from both the criminal trial as well as the evidentiary hearing, that evidence was already in and had already been presented to the jury. It was Exhibits 3 and 4 that were Officer Harrington's body cam and in-car camera that had been received and had been published to the jury at least a day prior to Mr. McDermott's trial testimony. His argument that he didn't recall it because he was busy passing notes to his attorneys trying to get it out is just unfathomable. And frankly, I think it strains credulity, to be perfectly honest. As to the issues of whether or not things go to his mens rea, as to what his thought process was, he did take the stand at trial. He, in fact, at the evidentiary hearing, stated that he was very pleased with his performance at trial because he told the truth. I don't know how, and I pressed him on this issue, of how further preparation with his attorneys would have changed his testimony in any way, shape, or form. And he was hard-pressed to give me any kind of an answer on that. And I failed to see how that could have possibly occurred either. Given the fact that the majority of the information that was obtained through cross-examination had already been largely put forth during the state's case in chief, and was also based upon his direct testimony, as cross-examination is in trial. Frankly, Your Honors, I think we're just really, the crux of this is that Mr. McDermott failed to reach his burden. And unless you have any further questions for me, I'm willing to cede the balance of my time.
Hearing none, thank you, Ms. Sorgan.
Thank you, Your Honors.
I want to touch on two things, excuse me, that the state just said. One, that they have no obligation to refute the claims. That's not true. Yes, the burden is on the defense, or excuse me, on the petitioner to assert a claim and then present evidence in support of that claim. But if the state then does not refute that claim, then that would be uncontroverted evidence in support of his petition for ineffective assistance to counsel, which is what I cite in my brief. The state seems to gloss over the fact that this is an ineffective assistance of counsel claim. He's saying his attorneys didn't do a good job or were unprepared and they didn't prepare him properly. And then in support of that claim, so that's the allegation, and in support of that claim are all of the facts that he testified to. And the second issue is that the district courts, I really want to, again, point to the paragraph 25 of the order, where the court says, McDermott appears to disagree with his counsel about not presenting information regarding stand your ground. From the record, it appears that McDermott and his trial counsel at some level have discussed defense. Again, he's telling, so the court is using, I guess, trial transcripts for the record. I'm uncertain what he's using, but Mr. McDermott testified I told him to do it. That was the extent of it. They didn't do it. That was the extent of the discussion. And our discussions were very brief. I met my counsel basically right before trial. and Mark discussions prior to that were non-substantive or were very short. So these are all facts in support of both prong 1 and prong 2, where he's telling the court, these are the facts that support my ineffective claim. Also, this is why my defense strategy didn't work. It's because they refused to present evidence that was necessary to do so. And then finally, just because I think that there's also a misunderstanding about the discussion to take the stand, not take the stand. It's not just that he thought his performance he did well under questioning at trial. It's the decision to take the stand opens you up to, essentially credibility attacks. And so if that's not really fully discussed with the defendant, they don't really know what they're getting themselves into. And I again go back to the fact that he still doesn't seem to really understand that self-defense is not an affirmative defense. He does not need to convince the jury that he was acting in self-defense. The state has to convince the jury that he was not acting in self-defense. And I think that that's clear from the record that I reviewed, that his counsel didn't explain that to him. And if his counsel didn't explain that to him, then he didn't take the stand in a knowing manner.
Couldn't the counsel have explained it to him and he still not understand it or forgot over the last 6 months or a year? I mean, you're assuming a lack of understanding is a lack of explanation.
But he testified that it didn't happen. So
I know, but you're arguing that his misunderstanding shows that counsel never discussed it with him.
So he testified that this conversation didn't occur. That's what shows it didn't occur. But I'm saying it seems supported in his further facts support that statement. And this is where I disagree with the state, that the state then has an obligation to put the attorney on the stand and say, no, we talked about it, and he made appropriate commentary or questions, and he understood, to my knowledge, he understood. That's the state's job. That's not the petitioner's job. The petitioner's job was to support his claim of ineffective assistance, which he did throughout this hearing and in his closing. And I also think that as Justice McEvers, you pointed out, there's no determination in the order that there was a lack of credibility. Nowhere in here does the judge say that.
Well, your argument about him saying he wouldn't have testified, at the hearing he says, I don't believe I would have made a different decision to testify. He just would have been more prepared.
Yeah, but again, yes, that was his statement.
But
he
the
doesn't.
evidence here is there's a video of the actual altercation. How can you overcome that video of the actual altercation?
Again, this goes back to what he was charged with, manslaughter and the lesser included of negligent homicide. No one's saying that he didn't shoot a gun. So it goes to mens rea. Thank you.
Thank you, Ms. Crosshart. And thank you as well, Ms. Sorgan, for your arguments this morning. This case will be taken under advisement, as all cases are, and this court will stand adjourned until 1:30 p.m.